You're not any good to anyone if you're using meth. You're not good to your daughter who has this brain issue and that's going in. You should not be allowed to be taking care of a 2-year-old and a 3-year-old. And I'm not going to allow that. And you need to get a job. There's no excuse for you not having employment. And if you're on deferred out of this court, I require people to have employment. And would your wife test positive? No. So here's the thing about that. Your wife then, since she won't test positive, she's holding everything down by herself. She has employment. She's dealing with her daughter who has these medical issues that she has to take to Houston. She can't depend on you to drive to Houston because you're using meth and drugs. She has a 2-year-old, 3-year-old. She can't depend on you. So right now, you're not bringing anything to the table. But when you're on deferred adjudication out of this court, you're going to bring something to the table. You understand? Johnny Ramirez for sentencing today. Off the record, defense counsel was telling me that he was going to ask for a continuance. Did you file a motion or no?
No, Judge, no motion was filed. I literally just found out that the surgery has not yet taken place.
All right. State, any objection to the defense's oral motion for continuance?
No, Judge.
All right. Court will hear argument.
Your Honor, for please the court, the child has an appointment in Houston for evaluation for brain surgery on November the 3rd. We're respectfully requesting that the court allow him to come back November the 10th for sentencing. He's already been admonished that the full range of punishment is available if he doesn't appear for sentencing.
All right. So, State, are you going to have any objection?
Just the same admonishment, Judge, the full range, and I would ask the court to remind the defendant that if you are inclined to grant this, that's the day.
All right. So here's my question. Counsel, you're an officer of the court. Do you have proof of this? Proof of the fact that there is a brain issue with his daughter? Do you have proof?
Judge, I have not had any independent investigation on my part. The representations made by his wife of what I am relying on, that the child has to go to Houston on November the 3rd.
All right. So with regards to her issue, does anybody have any medical documentation whatsoever?
My wife does.
All right. So let's, he says his wife has medical documentation. Counsel, if you could go take a look at that documentation and tell the court if it appears to be true.
Thank you, Your Honor.
Yes. So usually what ends up happening in cases like this, sometimes defense attorneys don't have a chance to file a motion for continuance because they learn of things right away. Now, some judges, they will say, absolutely not. You need to file a motion for continuance. But sometimes if there's an issue where maybe it's something that just happened, there's no way they could have known about it, I'll let them go on an oral motion unless the state says you can object to it, because legally, you're supposed to have a motion for continuance filed. And that motion for continuance has to be sworn to by attorneys, either the state or the defense. Either one of them file a motion for continuance, they have to swear to it. So whenever I have attorneys saying, I need a continuance and the state allows them to go orally, if they're saying, oh, my client has this happen or that happened, I want to know if they've investigated themselves. Because sometimes people will say, oh, this is going on, and then it's not going on. So because all attorneys are considered officers of the court, that we're not gonna be untruthful, I always ask them to go investigate. So now we're gonna find out if there's any type of documentation they have that there's a brain injury. For me, if they're saying it's November 3rd, I'm gonna accept that as true. But first, I need to see if there's an issue, because we've been here before for this. Now, some judges would say, that's my problem. You're going into custody day because that's what his agreement is, you're going to custody. But to me, everybody is a human being. I don't want to be the one that, you know, maybe his daughter is going into surgery and she would like her father to be there to kiss her or whatever. I don't want to be the one to say, oh, not going to allow that. To me, that would be very hard. And it would be different if this were a violent offense that he's charged with, but it's not a violent offense. So that's where we are. Oh, well, usually attorneys, they just file them. Like, sometimes it's the same day. And I know that's why I always tell people, you need to come to court and see how things really work. Because sometimes it's whatever can expedite things. For example, sometimes it is motions for bond reduction. People always tell you in college, oh, you need to file a motion to have the bond reduced. But sometimes attorneys just come before the court and they have an agreement and they do that. All right, we're going to go back on the record. In 2023 CR 6932. Oh, if you can come forward, Mr. Ramirez.
Your Honor, please report, I'd like to call Valerina Flores, the child's mother.
All right, so I know you're going to call her as a witness, but, and I will hear from her, but is there any documentation that you've seen?
I believe there is, Judge.
Okay.
The terminology is medical terminology. It doesn't say brain surgery, but it does list her maladies.
Okay.
If the court will allow me, she'll bring up the online medical record and can tell you what the different diagnoses are.
All right, we can bring her up, but counsel, I mean, you've looked at it. I'll take your word for it, but if you want to bring her up as a witness, we can.
Well, we might as well get on the record what those maladies are.
Okay, sure. And what is her name?
Valeria.
I'm sorry?
Valeria.
Valeria. All right, thank you. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Valeria Flores.
All right, defense.
Ms. Flores, if you would take a look at the online record in the section where it lists what the evaluations are on your child. A little further down. Right here. Can you read those out, please?
She has left hemiplegia.
All right, just 1 second. Let's do this. If you can move closer to the court reporter.
Okay.
And when you state whatever you're stating, if you can spell it, that'll
Okay.
make it easier for her. Okay.
Okay. Left hemiplegia. It's LEFT. Hemiplegia is HEMIPLEGIA.
And just spell it a little slower.
HEMIPLEGIA.
Yes.
Seizure disorder. Left hemiparesis. Left, and then hemiparesis is HEMIPARESIS. Cerebral palsy. Closed fracture of shaft of right clavicle. Closed fracture of shaft of clavicle. And then elevated blood pressure reading without diagnosis of hypertension.
Your Honor, to please support, those are what are listed in the medical records.
All right. Thank you so. All right, it's the court understanding is that both the state and the defense have entered into a new plea bargain agreement. Do you understand that?
Yes, ma'am.
And is that correct, state?
Yes, Your Honor.
Correct, defense?
Yes, Your Honor.
All right, so the same admonishments that I've given you before apply. Do you understand?
Yes, ma'am.
And are you waiving your right to trial?
Yes, ma'am.
So with regards to the enhancement, Which enhancement is he pleading true to?
It's the first, in the paperwork, it's the first one, Judge. It's cause number 2013 CR 1015.
Right. And how do you plead to that enhancement? True or not true?
True.
All right. With regards to the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes.
All right. So according to the plea, you agree that you've been previously convicted of enhancement. Paragraph 1, the punishment is to be assessed at 10 years in the prison. The state is silent on your application. Did you understand that to be the case?
Yes.
All right. And defense, is that the plea?
It is, Your Honor, with this application for deferred.
All right. And state, is that the plea?
Yes, Your Honor.
I'm going to show you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
And then state, it's the court understanding as well. And we're going a little bit out of order here because there's been a new plea bargain agreement reached. But state, are you offering into evidence state's exhibit number 2, which is the judgment?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
All right. And outside the agreement, the state is requesting a TAP evaluation. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes.
All right. You previously pled guilty. Do you still wish to enter a plea of guilty?
Yes.
All right. State, do you have any evidence to support this plea?
Your Honor, I offer state's exhibit 1 in the attachments.
No objection, Your Honor.
All right, the court has previously reviewed that. Mr. Ramirez, do you understand the previous admonishments that the court gave you with regards to state's exhibits 1 and 2?
Yes.
All right. The court has reviewed state's exhibits 1 and 2. The court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Do you understand that in regards to your application for deferred adjudication, if the court were to grant that, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Knowing that, do you still wish to apply for deferred adjudication?
Yes.
All right. Is there anything you wish to say on behalf of your client?
Judge, the court and the state are both being very kind. He has accepted responsibility for his actions in this case. And we respectfully request that the court follow the plea agreement and give him a deferred.
All right. Are you employed?
Actually, no, ma'am, I'm not right now.
All right.
Take care of my kids at home.
I'm sorry.
I'm taking care of my kids at home,
All right. How old are your children?
2 and 3.
And the 16-year-old?
She goes to school. She goes to school, and my other daughter goes to school too.
All right. If you're drug tested today, what are the results going to be?
Well, I am still dirty.
Dirty for what?
For both meth and for marijuana.
All right. So you shouldn't still be dirty for meth and marijuana since this plea was originally taken on October 13th. So it's clear to the court that you have a drug problem.
Yes, and nobody's ever given me no treatment.
No. We're doing this one step at a time.
Okay.
So you have a drug problem.
Yes, ma'am.
Your problem is with meth. And you're not any good to anyone if you're using meth. You're not good to your daughter who has this brain issue and that's going in. You should not be allowed to be taking care of a 2-year-old and a 3-year-old. And I'm not going to allow that.
I don't do it like when I take care of them and stuff.
No, right now, you should not be allowed to take care of 2-year-old and 3-year-old. Let me ask you this question.
Yes, ma'am.
Let's say you need a babysitter, right?
Yes.
And somebody has recommended me to you. I come out, I meet the family. Everybody says, oh, Stephanie's great. So I come out to your house and you and your wife say, you know what? We're going to see if the children like her. Children love me. I'm the Black Mary Poppins. You all take a break. You said, we're going to test her. We're going to turn on cameras and we're going to tell her we're going to the store. You go to the store, I'm still the same great person. And you come back and the children are like, please, can we keep the Black Mary Poppins? And you guys say yes. So you all decide to hire me. And I'm like, oh, I'm so excited. And then as I'm walking out the door, I said, you know what? You guys seem like a nice family. Your children are nice. Let me just tell you something about myself that nobody knows. And I tell you, I use meth and marijuana, but don't worry. I'm not going to use meth and marijuana over the children. I will do it before I come. Are you still going to let me be a babysitter? I'm sorry?
No, I wouldn't.
That's what you're doing. So I'm not going to allow it.
I don't want, I pick all that stuff.
So you're not going to be allowed to take care of a 2-year-old and 3-year-old. You understand? And you need to get a job. There's no excuse for you not having employment. And if you're on deferred out of this court, I require people to have employment. And would your wife test positive?
No.
So here's the thing about that. Your wife then, since she won't test positive, she's holding everything down by herself. She has employment. She's dealing with her daughter who has these medical issues that she has to take to Houston. She can't depend on you to drive to Houston because you're using meth and drugs. She has a 2-year-old, 3-year-old. She can't depend on you. So right now you're not bringing anything to the table. But when you're on deferred adjudication out of this court, you're going to bring something to the table. You understand?
I promise you I will. And change.
All right. It's going to be 10 years deferred adjudication. We're going to do a TAP evaluation. And he's going to follow TAP recommendations. So if it recommends inpatient treatment, you're going to inpatient treatment. And the fact that your daughter has a medical issue, you're still going into inpatient treatment. You understand?
Yes, ma'am.
And counsel, if you can see, maybe Lifetime Recovery will accept him into their inpatient program.
I'll check on that, Judge.
All right. There is going to be the UA hotline, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Doesn't matter if it's your child or not, you're not to have unsupervised contact with them. So there needs to be an adult if you're going to be there. And if the adult says, I need to go to the grocery store real quick, you take care of the children, you better tell them no. You understand?
Yes, ma'am, I will.
I'm going to want field visits 1 time per month until further notice or until he's at the Lifetime Recovery Residential. Regular reporting by Zoom or in person. $200 hours of community service restitution. That will be waived upon completion of parenting classes. And probation, whatever parenting classes you all deem is necessary. All right, probation, is there anything else he needs?
No.
All right, is there anything else you need from this court to be successful? Do you need anything else to help you not come back here for a revocation? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, so off the record. From here on out, everything you do in your life, you know what you need to ask yourself some questions before you do it. 1, is this something that could potentially result in me going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. The only reason why you have this agreement before you right now is because of your daughter's medical issues, not because of anything that you have done. So you had better take this opportunity to do better and not use drugs. All right. Good luck to you.
Thank you, Your Honor.
You're welcome.
And spoken to the state, they need to look further into it before they can make the offer that we're asking for. So we're just asking for a reset to give them that time.
All right. And how long is that going to take?
I think a month would be reasonable, Judge.
And if they get me the offer in the meantime, the offer would end up being a plea to the misdemeanor and a dismissal on this. So we'd end up getting that set. That way we wouldn't even be back on the next setting on this one.
All right, Ms. Ferguson on MC Reed, if I can have a 30-day reset.
Yes, ma'am, the 27th.
All right, we'll come back on November 27th. Once you sign the reset form, you're excused. Mr. Reed, you need to make sure you're on time next time, okay?
Yes, ma'am.
So what does the MC stand for? I know we had this discussion.
It's my real name. I'm a junior.
Oh, okay,
Okay.
awesome. But see, I always think that letters MC have to mean something.
In most cases, they do stand for stuff, but in my case, I guess the generation that was before me, they just use letters sometimes.
Okay.
JB or JL.
Ah, okay. Now, when you said JB,
Yeah.
I understand now.
Yeah.
Okay, awesome.
Yes, ma'am.
All right. Once you sign the reset form, you're excused.
Thank you, Judge.
All right, you're welcome. Ricardo Tavares. Hello. Court is calling 2023 CR 7145, State of Texas versus Ricardo Tavares. Could I have parties announced for the record for the state
Jason Garrett, Your Honor.
defense?
Written for the defense.
And are you Mr. Tavares?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tavares, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 1, 3, and 4, and proceeding on count 2 alone.
Any objection?
No objection.
Mr. Tavares, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count 2, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That is a second-degree felony. Off the record for a moment. Probation, this is no application. And we're back on the record. The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Tavares, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 2. There are no applications, and they're asking that your punishment be assessed at 3 years in the prison. Did you understand that to be the plea?
Yes, Your Honor.
Defense,
Yes, Your Honor.
state,
It is, Your Honor.
showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, Your
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There were none, Judge.
Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State exhibit number one with all the attachments.
We have no objection.
All right, state, you may continue to confer. Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will client.
Just ask to follow plea agreement.
All right. Court will follow your agreement. The court will sentence you to 3 years in the prison, give you credit for any time served. Is there anything else with regards to sentencing?
Nothing further, Your Honor.
All right, Mrs. Tavares, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
I'm 35.
All right, do you have any children?
Yes, I do.
All right, here's the thing. You know that life keeps getting short for people. I can say that I'm in the twilight of my life. You're going to have to make a decision on if you're going to change or if you're going to spend the rest of your remaining time on this earth in and out of jails, in and out of prisons. I'm sure your children would love for you to be clean and sober in their life. If there's a drug or alcohol problem, there are plenty of free places. If you would like, I could actually have you referred to the therapeutic community at the prison. It will not increase the length of time that you're in prison. So for example, if they're going to parole you at 2 years, they're not going to say, we're not going to parole him because he's in the therapeutic community. It's just something to get you on the right track. Would you like that?
Yes, Your Honor.
All right. Caroline, can I see the following Tavares again? All right. Well, good luck to you. Okay.
Thank you.
All right. Good seeing you. Yes. Victor De La Vega. Who's the attorney for Victor De La Vega? Cornelia Childress. Thank you. I love the pen. All right, so Cornelia Shalom Childress, if you'll come down, please. Court is calling 2023 CR 0923, State of Texas versus Cornelia Shalom Childress. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense? And are you Cornelia Childress?
Yes, ma'am.
I'm going to show you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Cornelia Childress who was placed on community supervision in 2023 CR 0923 for the offense of felon in possession of a firearm on May 30th, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number one, on or about the 24th day of August 2023 in Bear County, Texas, the defendant Cornelia Shalom Childress committed the offense of possession of controlled substance, penalty group 1, in violation condition number 1.
How do you plead to that? True or not true?
No contest. Okay, true.
I'm sorry. So to violation of condition number 1, how do you plead?
True.
Right.
We'll waive the remaining violation.
Any objections to state's waiver? All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 4 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that you still wish to plead true to violation of condition number 1.
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is. It is to revoke the individual off for probation and to reform the underlying sentence of 4 years to 3 years in Texas Department of Correction, and the state will take into consideration cause number or nightbag number 726987, which she pled true to.
All right.
That is our agreement, Judge, and we'd just like to tell the court that she has 284 days credit that she would like to add for.
All right. Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. The court is going to find violation of condition number 1 true. Court will grant the motion, sentence you to 3 years in the prison, give you credit for any time served. Take in consideration NIMAG number 7266987. All right, if you all are behind, I make this announcement every time. If we're on the record and you're behind the court reporter, just ask to move to the other end. All right. Ms. Childress, I pronounce sentence. If you would like, I can ask them to refer you to the therapeutic community. It doesn't increase the time that you're in custody, but it could potentially help you get on track with your life. Would you like that?
Yes, ma'am.
All right, so I'm going to order the therapeutic community. You'll still need to ask for it when you get there because I have no jurisdiction to force them to place you in the program.
Yes.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. I see that I ordered parenting classes for you.
Yes, ma'am.
You are going to have to get your life together, because if you don't, somebody else is going to be raising your children, right?
Yes, ma'am.
And I always tell people a mother's love is different from other person's love. But if you have no plans on improving your life, don't come in and out of your children's life. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
You're
Thank you, Judge.
welcome.
May we be excused?
Yes.
Thank you.
Sarah Gutierrez.
Morning.
Good morning. How are you doing today?
We're doing well. How are you?
Oh, I cannot complain. It's a beautiful day.
Yes, ma'am, it is.
The sky acts as though we're trying to get some cool weather. LSU won, so I don't know what else we can say about that.
We're rolling in just as much as everybody else.
All right, so on this case, all right, state is to make an offer. State, did you make an offer?
Yes, Your Honor.
All right, we're going to recall this in 2 weeks. In 2 weeks, you need to let the court know if you're accepting the offer.
We can do that, Judge, but in the meantime, I did want to bring something to the court's attention. There has been, I've been out the last month, but in my absence, there was some issues that arose from Ms. Gutierrez's case with her family, and she was recently released from Laurel Ridge.
Okay,
I believe, just based on some communications that have occurred, and just, I would like to be cautious. I would request if we could be referred for an evaluation for competency for Ms. Gutierrez.
Okay. All right, Ms. Ferguson,
Yes, ma'am.
on this case, give me a 45-day reset, and we need to refer her to Judge Carruthers for a competency.
I can do December 7th.
All right, and Ms. Ferguson, if you'll make sure that's filed.
Yes, ma'am.
All right, do you want the court to file that, or are you going to do it?
For the
Competency.
request for competency, I can file that later this afternoon if the court. if the court
Well, they
wishes.
will file it later this afternoon.
Thank you.
All right, thank you.
Thank you.
You're welcome. Once you get the reset form, you're excused.
Yes, Judge. Thank you.
Thank you. Luis Camacho. Where's the attorney for Luis Camacho? Oh, sorry. All right, we're here for discovery on the body cam. Where are we on that?
So I did receive the discovery for body camera early on, Your Honor. In this case, the issue was that of witness names for information that was discovered on one of the body cameras. I guess the state can update, well, I think they essentially hit a point in this case where it may require further investigation from the defense potentially, or maybe a motion. But in the meantime, the state has extended an offer. We would request, just given these circumstances, if we can be given a plea deadline for Mr. Camacho.
All right, Ms. Ferguson, if I can have a 30-day reset on this case for plea deadline date, and it's Camacho.
The 28th.
All right, we'll be back on November 28th. Once you sign the reset form, you're excused.
Yes, ma'am.
All
Thank you.
right, thank you. Stephen Rose. Who's the attorney for Stephen Rose? All right, just have a seat. Jose Angel Ruiz. Hello. How are you? Oh, I'm doing great.
Yeah.
I'm sorry.
You're not gonna have enough room.
Hello. So we are here today for a jury trial date.
Your Honor, it was my understanding this was a status update. Because there was some discovery and I do need to inform the court that pursuant to 3914 and Brady, we learned some information this morning. We will need to interview a prospective witness. And so we're asking for another, at least two witnesses that we know. So we are asking for another discovery setting.
I'm giving you guys a jury trial date. This has been going on with discovery since June 9th, 2022. So it's been all this time for discovery. I realize defense attorney's been changed, but we were here for discovery in June. Then we had discovery in August, and that discovery was related to the autopsy, which I know none of you indicted a case without an autopsy, but that's neither here nor there. Then we come back in September. In September, another discovery issue with autopsy. Then we come back on December 1st. Then we have DNA comparison that needs to be done. Then we come back on February 3rd. Then we come back on March 2nd. Then we come back on April 4th. Then we come back on April 12th. Then we come back on May 25th. Then we come back on June 1st for a plea deadline date. Then it gets recalled for June 5th because we have this whole attorney issue. Then we come back on June 5th. It was supposed to be a jury trial, but then no, we reset it for October 3rd. And then we say, all right, we're going to recall for October 23rd. I granted a motion for continuance. And then this date is the day that we get a jury trial date. So whatever you all want to do on off docket, whatever y'all want to do in Brady, y'all want to talk to some witnesses, then y'all talk to those witnesses. But you all are getting the jury trial today, and you all need to handle whatever discovery you all need to handle off docket.
Judge, may I say something?
Sure.
I know when we hear that from you, it sounds like, what are y'all doing? And it really is a case that's not, what's the right word? It's simple. It's not simple. The discovery and evidence is evolving because of the complexity of it. Now, if these witnesses have exculpatory information, obviously we want that and we want time to deal with it. Right now, they don't know exactly what the nature of it is, but.
So here's my question. When were these witnesses discovered? And did these witnesses just drop out of the sky, somebody indicting cases without
But they don't.
talking to witnesses?
Your Honor, this particular witness, I believe.
Yes, he was a fugitive judge. I did personally indict the case. I did have an autopsy for the record when I indicted the case. However, this witness, no one was able to find him to interview him. He has now since picked up criminal cases. This morning, we were able to meet with his attorney. We have not met with him. We met with his attorney.
So where is he?
He is in custody.
At the Bexar County Jail?
Correct.
So then those witnesses' statements should be able to be done this week. So next.
But that's taking it, you've got his attorney that has to talk to him and then make him available to meet with them. I mean, It all takes time, as you know.
Today is Monday. That needs to be done this week, or how are you guys gonna do it?
And then there's another issue too, which is that we have, the discovery's massive. And we have, external terabyte number 1 that we have received. And we have external terabyte number 2 that was handed to us unopened and unviewed. And because of content, possible content on there, it was returned to the DA's office. Okay, so there's a second 1 terabyte hard drive that is not in the possession of the defense, but available to the defense to view. The fact that we can't possess it and we have to go to the DA's office to view it also is a time-consuming thing.
Oh, let me just tell you, the state is going to be available whenever you all are available to go over there. And if you all want to set a setting in this court to come down and view it, you can set a setting in this court to come view it. How long have you been in custody? A year and 10 months. This is going to trial before the new year. Ms. Ferguson, give me a trial date for this case before the new year. How long do y'all expect this trial to last?
2 weeks.
All right, it's a 2-week trial setting.
I would say today's October 23rd, 22nd.
So everybody have all the month of November and the end of this month. What date, Ms. Ferguson?
So it's December.
December 12th, Judge.
All right, December 12th.
Judge, is that not gonna put us into Christmas if it's a 2-week trial?
Yeah, that
They'll be
might.
here for Christmas. All righty, thank you all. Is the attorney here on Victor De La Vega? All right, Victor De La Vega. Hello, are you not hot?
No, I was really gonna sweater.
Oh, okay. All right, so what is happening on this case?
Yes, Your Honor, the state has made an offer of mental health PTD on one of the misdemeanor cases. Once we are going to ask for a reset so we can apply into that course.
Okay.
And once he gets accepted, then I believe this felony case is going to be TIC'd along with all the other thefts.
All right, Ms. Ferguson, so you're doing PTD in misdemeanor court?
Yeah, yes, Your Honor.
All right, can we reset this for 30 days for an update on the misdemeanor PTD?
And Judge, just to clarify, it's gonna be the mental health court PTD.
Yes.
Ah, mental health court, okay. What date, Ms. Ferguson? Yes, it's for mental health. All right, we'll come back on November 30th to see where we are. Once your client signs the reset form, you're excused.
Thank you, Your Honor.
You're welcome. Ruiz, I think. Oh, yeah. Thomas Henson. Oh, just 1 second. Are you all ready to proceed on the motion?
Yes, Your Honor.
Yes, sir.
All right, is this going to be contested or no?
No, Your Honor.
All right, I don't have an, I do. All right, the court is calling 2022 CR 5859, State of Texas versus Thomas Nathaniel Henson. Could I have parties announced for the record for the state,
Zach Dunn for the state.
for the defense?
Catherine Valenzuela.
Are you Thomas Henson?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes.
Are you the same Thomas Nathaniel Henson who was placed on deferred adjudication in 2022 CR 5859 for the offense of aggravated assault with a deadly weapon on September 15, 2022 for a period of 4 years?
Yes, sir.
State?
Your Honor, on or about the 11th day of August 2023 in Bear County, Texas, the defendant, Thomas Nathaniel Henson, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
State,
And Your Honor, there's an agreement.
the other allegations?
There are none, Your Honor.
Are you waiving?
Yes, Your Honor.
All right, any objections to the waivers?
No objection to the waivers.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yeah.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor. We had an agreed recommendation to continue and for DDRF.
That is understanding, Your Honor.
All right, probation, is that your recommendation?
Yes, Your Honor.
What is the wait time for DDRF?
Honor.
The wait time is 6 to 13 weeks. Do we have any other alternatives?
State ISF cognitive track, Your Honor, that wait time.
All right, but will that address the issue? Because DDRF, I'm assuming there's a mental health issue.
And Your Honor, that had been the first recommendation, then he did the tap about, and that's why we got to NDRF, but the first recommendation had been ISF cognitive.
All right,
Sorry.
no problem.
So yes, the original recommendation was for the state ISF cognitive track, but we did an updated tap while he's been in Bear County, and the recommendation changed for DDRF due to the mental testing.
All right, so the new number 1, who is the complainant? I mean, what is the relationship?
She's been my girlfriend.
Girlfriend. All right, and are we doing no contact with the girlfriend?
I believe there had been, she did sign an affidavit of non-contribution. We did enter plea to proceed with the treatment that he believes he does need, Your Honor.
All right, so I'm going to order no contact with that person. And then once his mental health is stable, we'll do something different. Do you understand? I'm sorry, you need to speak up. All right, so do you have anyone else that you can live with? Mother?
I wasn't just living with her. She was living. I mean, she was staying.
Okay, you're mumbling. I can't understand. I can't hear you in the court report. I can't hear you.
I wasn't living with her. She was staying with me. So.
All right, so do you have your own place?
Yeah.
So who were you living with?
Yes, I was staying with my grandma.
All right, so you need to stop inviting people to live with your grandmother when she's already have you living with her. You understand?
Yeah.
So were you supporting yourself at all? Or were you just dependent upon your grandmother?
I mean, I wasn't paying rent, but I wasn't.
Were you working? I'm sorry, I can't hear you.
Sometimes.
So that means that you're not bringing in a stable income and you're bringing somebody else into your grandmother's house. That's a big no-no. You understand?
Yes.
All right, probation, anything with Center for Healthcare Services or?
Your Honor, I think. And I know that the state waived and abandoned the other allegations. However, he last reported to probation in March. So that's a concern for us. Right before he absconded, he did produce one negative UA, the others were positive. He did not complete his hostility management course that was originally mandated. I think our concern would be that he would abscond again without actually getting the help that is necessary.
All right, do you want to go to prison? Because we can do that. Then why are you behaving as though you want to go to prison by not reporting? That's the easiest thing on the planet to do. You're obviously not working really. So you're just watching television with your grandmother or something, or putting a burden on her where she has to feed you and then you're bringing a girlfriend into the house. That seems like all you were doing and not doing well on probation. Do you want to go to prison for up to 20 years? All right, this is what I'm gonna do. I'll deny the motion. There's to be no contact with the complainant, whatever her name is, give that to probation. So the complainant and condition number 1, you are not to have any contact with her. Do you understand? So as far as your probation is concerned, that relationship is over. Do you understand? Do you have any children with her? So that relationship is over. If you end up violating my order and having contact with her, you could potentially go to prison for 20 years. Do you understand? And we're going to do state ISF, cognitive and substantive track. And then we'll see where that leaves us.
Okay, Your Honor, I do want to point out that the way that state ISF is being ran now, it's not a double track anymore. It's either one or the other.
We'll do cognitive.
Thank you, Judge.
And then after that, when he's released, we'll put him on GPS, partial for work, until further notice. And you to reside at your grandmother's house. You understand?
And Your Honor, for Mr. Henson's benefit, what are you looking for, or what is the court looking for so that he could get off GPS? I mean, just so that he knows, like, if he's always reporting, attending.
Oh, he needs to show me that he's actually taking this probation seriously.
Okay.
If you're not taking it seriously, what's going to end up happening is a motion to revoke is probably going to be filed. And instead of you worried about GPS, you'll be looking at potentially 20 years in prison. Do you understand?
Yes.
All right. And see probation if those fees can be waived.
Thank you.
All right. Thank you.
Thank you. Thank you, Judge.
You're welcome. Annette Idrago. Who's here on Annette Idrago? All right, where is she? Have her come forward.
She's right here in custody.
All right, state on this case, my understanding, she has a case, another case. And you all were going to be looking into that. Where are we on that?
She was, may I address the question?
Yes.
She was picked up on that this morning, Your Honor. There was a
Okay.
bond increase on the other case, is my understanding, for $100,000.
Mhm.
So I don't know if she's gonna make that or remain in custody, but either way, if I could just get a little bit of time to look at the new cases, you can call this back anytime.
All right, Ms. Ferguson, on Idrago, if I can have a 30-day reset, please.
November 28th.
All right, November 28th, and state at that time if you could tender an offer.
Yes, Your Honor.
All right, thank you.
Your Honor, can we do it the week before?
All right, Ms. Ferguson, can you put, are we gonna have to charge it?
Your Honor, they are actually charging the phone right now in anticipation that this may, it needed to be produced. I would just need to, if it's going to be a true contested, I just need time to get the officer here with the phone.
All right, so when do y'all want to set this? How much time y'all need? Just to let the court
I
know.
just looked at it today, Judge. So
Okay,
it was special crime, but apparently they're too special to.
you're too special.
Handle this, okay.
All right,
Next week sometime?
well, I don't know if that's enough time for them.
Okay.
At least to,
Sorry.
what do you,
About whether we would, since it is a cell phone, my understanding, it was consensual, like as in the sense of the search. So
Okay.
that would just be a question. I don't know, that'd be an issue for defense, but
Well, I think they're making allegations that he was using the cell phone for this,
well, I mean, is there going to be
Stop it.
objection? Because they're saying that the searching of the phone was consensual.
right, it may have been, but they're saying that there was communication on the phone that he was trying to hook up with people and stuff.
Okay.
He's disputing that aspect. So if he had a phone, that's another thing. If he's trying to hook up with these people, that's a different thing.
Okay, all right, Ms. Ferguson, can you recall that, is 3 weeks enough time for everybody?
Yeah, that'll work.
Can you recall this in 3 weeks for potentially a contested? All right, November 16th. Yes. Mr. Bueno, we're going to bring you back on November 16th and they'll have the cell phone here for you. Oh, just have a seat unless they're ready to take you back. Stephen Rose.
Thank you, Your Honor.
You're welcome. Have a great day. All right, who's here on Stephen Rose? All right, so what is happening with this case?
Judge, I have an offer and I discussed it with my client and he wants to set the case for jury trial.
All right, this is possession of body armor.
Yes, sir.
State, how long do you anticipate this trial taking?
Including selection, Your Honor, probably 2 days.
All right, Ms. Ferguson, this is 2 days. Can I have a jury trial date, please? And it's criminal trial division. All right, we'll be back on December 5th for a jury trial. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right. And counsel, you need to sign. Oh, I do have the acknowledgement of discovery, so that's done.
Thank
All right,
you.
thank you. Once you get the reset form, you're excused. Jose Ruiz.
Okay.
Hello.
I didn't. Are we on the record, Judge?
You want to go on the record? We
Yeah.
can.
Uh-huh.
All right. Court is calling 2022 CR 4248A, State of Texas versus Jose Angel Ruiz. Can I have parties announced for the record for the state?
Brittany Mitchell and Marissa Giovanco for the state.
For the defense?
Lisa Connolly and Lorraine Efron.
All right. And are you Mr. Ruiz? All right. What would you all like to put on the record?
That in conferring with the state today, it's come to our attention that there's the possibility of some newly discovered Brady exculpatory evidence. And I understand that the DA's office needs time to work out arrangements with the attorneys representing the individuals who have the evidence and to turn that over. And so we are, obviously, we want all of the Brady and exculpatory evidence that we're entitled to, and we want an appropriate amount of time to deal with that. At this moment, I don't know how much time we would need to deal with it because it's not in my possession. But that was one thing. And then the other thing is that there are some pretrial matters that may require some rulings, such as a motion to suppress oral and written statements. Now we're going to confer and see if we can reach agreements on redactions, but it's possible that we're going to need a pretrial hearing on some pretrial matters. So I don't know how the court wants to handle that.
All right. So with regards to the communication with this witness, you all can pick up the phone, call the defense attorney, ask the defense attorney, hey, are you able to come to the 187th this week? And guess what? We will have whatever witness y'all want brought over at that attorney's behest, and y'all can talk to him in court in the afternoon. This jury trial is going to be set for December 12th. With regards to any motions to suppress issues, you all can come back all this week and see if y'all can agree on something. If you can't agree on something and you all want to have a hearing, a pretrial hearing on any suppression issues, Ms. Ferguson, can we set those pretrial matters for, let me see. If you can set those pretrial matters for the week of November 13th. So if anybody has some suppression issues, anything that you want heard, state, Ms. Ferguson will give you a pretrial setting for the week of November 13th, and everybody's to have their witnesses here.
Okay.
All right.
That sounds good. And we'll do our best to confer on everything that we can, and whatever needs to be resolved, we'll present.
All right, awesome.
Okay.
Thank you. Alicia Marino.
We can bring it up that day.
Hi. Hi, excuse me.
Okay.
Let's call another case. Come forward, Alicia Marino. And probation, this is an application. Court is calling 2022 CR 6082A, State of Texas versus Alicia Marie Marino. Can I have parties announced for the record for the state?
Yes, Your Honor. Luis Echeverria for the state of Texas.
Defense?
Andrea Matos for the defense.
Are you Miss Marino?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Miss Marino, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes.
And did you sign it? Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to waive and abandon counts 1 and 2, proceed solely on count 3, state jail felony, Your Honor.
Any objection?
No objection, Your Honor.
All right, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on count 3, which is theft $2,500 to $30,000? That's a state jail felony. Range of punishment is anywhere from up to a $10,000 fine, anywhere from 180 days up to 2 years in the state jail facility. Did you understand? If you have a plea bargain agreement with the state and the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 3. There's a $500 fine. State recommends deferred adjudication, and there's to be restitution to whom?
Judge, it's to, well, it's going to be both to the Texas Lottery Commission and that amount.
Do you all did not put that in your agreement?
Well, Judge, I want to leave it open so that probation can ascertain it, but according to the prosecution guide, it is $1,870 to the Texas Lottery Commission and $2,929 to Easy Mark. Would you like me to write that
All
in,
right.
Your Honor?
Yes, you all need to write in here, not necessarily the amount if you don't agree to it, but to the parties.
Today's courtroom hearing turned emotional when a father stood before the judge asking for more time before sentencing. His attorney explained that his 16-year-old daughter was suffering from serious brain problems and could soon need surgery in Houston after suffering repeated seizures. The judge didn't immediately accept the request. Instead, she carefully questioned the defense and asked for proof that the medical emergency was real. After reviewing the records and hearing directly from the child's mother, the courtroom mood completely changed. The judge told everyone that while some courts might have sent the defendant straight into custody, she believed people are still human beings. She openly said she didn't want to be the person responsible for keeping a father away from his daughter during such a terrifying medical situation. But later in the hearing, the judge also confronted the defendant about his ongoing meth and marijuana use. She firmly warned him that a parent using drugs could not properly care for young children, especially a child facing life-threatening health problems. The judge ordered treatment, strict supervision, parenting classes, and repeated drug testing, while warning him that this second chance was only happening because of his daughter's condition. The emotional exchange ended with the judge telling him that every future decision now had to be about staying out of prison and becoming a better father for his children.